Yes.
The Lord, ground 2 of the appeal, we addressed this in our skeleton argument of paragraphs 34 and following. And this is on the assumption that we are wrong on ground 1 and that an agent's signature is not sufficient for the purposes of section 53(1)(b). I do make the point in passing that it is an exceptional statute which mandates personal signature. That's a point made by, I won't turn it up, but Lord Justice Lewison in the Northwood case that Mr. Grant referred to. And the reference is Authorities Bundle tab 88, page 12, paragraph 30 of Lord Justice Lewison's judgment in Northwood. PDF is 1867.
Yeah.
And we say that if personal signature is required, then the signatures on the deed of mortgage and the certificate of title constitute the signatures of NIOC for the purposes of section 53(1)(b) in any event. It raises the question of how a company is supposed to sign a document personally. As my lords and my lady know, the court below found that the only signature which would suffice would be the signature of a director of NIOC. If we look at the judgment at paragraph 197, which is Core Bundle tab 15, page 201. And you'll see at paragraph 197, does my lord have that? Paragraph 197, Sir Nigel Teare says a corporate body acts by its officers, or as it's put by counsel for NIOC, the alter ego of a corporate body is its board of directors. Thus, a signature by director of a company would be a signature by some person who is able to declare such trust. And in our submission, there is a
implicitly accepting director or officer, really, isn't he?
Yes.
Because he talks about officers, but it's the same point.
It's the same point. And we say that a director and a company's board of directors are two different things. And one needs to find some kind of distinction between an agent and a director. Now, a company's board, maybe it's directing mind and will, but it doesn't mean that each individual director can be identified with the company in that way. The extent to which an individual director is able to bind a company is determined by reference to the authority conferred upon him, in the same way, we would say, as any other agent of the company. And again, in the interest of time, I'm not going to turn it up, but the point is made clearly in a case called Mitchell and Hobbs. It's Authorities tab 81, PDF PDF page 1663, and one can get all the facts from the head note, but the director issued proceedings in the name of a company.
Shall we just get that on screen?
Yes, of course. It's Authorities 81, tab 81, page 1. The PDF reference is 1663. Just glance at the head note.
Yeah.
And you'll see that a director issued proceedings in the name of a company, and those proceedings were struck out because there was no evidence that the board had authorised the proceedings or that there had been any other authorisation of the director to issue the proceedings. Now, my lords, my lady, the true position is that where a statute requires a personal signature, that requirement is satisfied in the case of a company by the signature of any authorised agent. This is made clear in the decision of this court in the UBAF case, which is at Authorities tab 123, And if I can just summarise the basic facts, this was a claim in deceit and misrepresentation. Plaintiffs allege that the defendant had misrepresented the creditworthiness of two companies to which the plaintiffs had then extended credit. The misrepresentation had been made by way of a letter signed by the defendant's assistant secretary. We'll come back to that. And at first instance, permission to serve out of the jurisdiction had been set aside on the basis that the signature of the assistant secretary did not constitute the signature of the defendant for the purposes of Section 6 of the 1828 Statute of Frauds Amendment Act, i.e. Lord Tenterden's Act. We can see the terms of that Act at page 718G of the report, which is page 6 in this tab, PDF 2485. You'll see Section 6 of Lord Tenterden's Act between F and G. And the court at first instance had found that a document satisfying Section 6 of the Lord Tenterden's Act must be signed by the defendant himself and not via an agent. And that is made clear in the case of Swift and Dewsbury, quoted at 721, which is page 9 of the extract. Swift and Dewsbury, we'll see cited letter D. This led to consideration of the very point before this court. If the statute in issue requires personal signature, how is that satisfied in the name of a company? And if I could ask the court please to look at page 719, which is page 7 in this tab. If the court could read, please, from letters F and then over the page to C.
Go over the page then, please.
So the first point to note is that Lord Justice Ackner records at 720B to C that it is not clear what, quotes, Assistant Secretary means, and that evidence will be required to determine the point. It's not assumed that Mr. Makeras was a director, board member, or some other type of officer, or even an employee. And as one saw from page 719H, Mr. Hoffman QC for the defendants sought to approach the matter as the judge did in our case by looking for some kind of alter ego of the company. But this approach was rejected by the Court of Appeal, and you'll see what at the bottom of page 7.
Yeah.
that Mr. Hoffman contended both before Mr. Justice Leggett and before us that in order to cause a corporate person to lose the protection of the section, signature must be that of a person who is the corporation's alter ego, a description which, with respect, we find, and then over the page, largely meaningless, save as an indication of some very wide but undefined authority, felt compelled to accept, and we think rightly, that at least if Mr. Macaras had been specifically authorised by a resolution of the board to sign the representation, then the defendants would have been bound. And then if we look at page 70, page 720, page 8 of the transcript, see that Lord Justice Ackner says at just below, between letters C and D, that there's a longer answer, which despite the temptation we don't think we should avoid giving. And then they go on, please, go to page 12 in this tab, it's 724 of the judgment. We look just above letter F. What is said there is that Parliament is continually placing the obligation on corporate bodies to serve notices in writing of one kind or another. In the case of local authorities, expressly provided for such documents to be signed by the proper officer. Since a company, not being a physical entity, can only act in relation to the outside world by its agents, no one nowadays would question that the signature of the duly authorised agent of the company acting in the course of the company's business is the signature of the company. And then he gives an example, and then just above H, no one would nowadays question that this signature is to be taken as a signature of the company. Do not therefore find any impediment in authority against deciding, and we think that it should now be decided, that the signature on behalf of a company of its duly authorised agent acting, and then over the page, within the scope of his authority, is for the purposes of Section 6 of Lord Tenterden's Act, the signature of the company. Duly authorised agent. And we say, my lords and my lady, that this decision, which is obviously binding on this court, is determinative of the issue, even if Section 53(1)(b) can only be satisfied by the personal signature of the person declaring the trust. That requirement is satisfied in the case of corporations by the signature of a duly authorised agent. And looking at my learned friend's skeleton, paragraph 68 to 73, we don't really discern any answer to UBAF. It's noted that attribution is context sensitive and that Section 6 of Lord Tenterden's Act operates in a different context to Section 53(1)(b), which of course basic level is true. But in our respectful submission, the differences don't really assist CGC. Section 6 of Lord Tenterden's Act is concerned with restricting the circumstances in which a person might be liable for fraud and ensuring that a person is only liable for the representations which they make personally rather than via agents. No reason why the class of persons who might sign such a notice might be wider than the class of persons who might sign under Section 53(1)(b). On the contrary, given the seriousness of an allegation of fraud, one might expect Section 6 to be somewhat narrower in scope than Section 53(1)(b). Now, even if we are, let's say I'm wrong about UBAF, then we say that a document will be treated as signed by a company and not merely by its agent if it's signed in accordance with Section 44 of the Companies Act 2006, as amended in the case of overseas corporations by Regulation 4 of the Overseas Companies (brackets Execution of Documents and Registration of Charges) Regulations, 2009. Just to show the court where this is, it's at Authorities tab 21, page 1, PDF, page 131. I'll come back to look at the provisions, but the key provision is 44. And we say that this proposition is established by the cases of Hilmy, and also, we won't turn it up, it's a first tier tribunal, this is the decision in a case called Schechter. Hilmy is at Authorities tab 58. Again, a decision of this court, and the facts are relatively simple if I can just summarise them. The question before the court was whether a company had signed a notice under section 99(5)(a) of the Leasehold Reform Act. And section 99(5)(a) was described in the Northwood Solihull case as an exceptional instance of a provision which required personal signature, which excluded signature by an agent. In this case, a single director had signed the relevant notice on behalf of the company, and the Court of Appeal held that signature was not sufficient, and what was required was compliance with section 36A of the Companies Act 1985, what is now section 44 of the 2006 Companies Act. You see that from paragraph 31, page 10 in this tab. The court could just glance at that paragraph.
Slightly, I'm possibly missing something. How does that fit with your interpretation of UBAF?
Well, I'm about to come to this. In our submission, the problem with this is that UBF was not cited to the court.
Oh, I see what you're saying. Okay. So you would say they didn't even need to.
So they didn't need to comply with section 44, but if it's necessary, then we get over this alternative hurdle as well. But just on my lady's point, if one looks. The court didn't have the benefit of Mr. Rokerson and Mr. Hoffman as he then was making submissions to them. If one looks at paragraph 17, page 6 in this tab, and my lady sees paragraph 17, despite their researches, neither counsel before us was able to put forward any case in which a court has had to consider how a company can and does sign a document personally. And if the court had been shown UBAF, there obviously was a case which was directly on point, but it wasn't cited. So UBAF appears to have been missed. And Hilmy is, with respect, per incuriam, and is not binding on this court on the question of whether signature of a document by a properly authorised agent constitutes signature by a company. And in our respectful submission, the judgment of Lord Justice Ackner in UBAF, which is binding, should be followed by this court. But even if the court is not with me in relation to UBAF, Hilmy is authority at least for the proposition the document executed in accordance with section 44, then section 36A of the Companies Act, does constitute execution by a company. and the court has seen paragraph 31 of the judgment already. To the same effect, I'm not going to turn it up in the interest of time. It's a decision of the first tier tribunal in Schechter at paragraph authorities tab 111, PDF 2261, the tax appeal, and the relevant paragraphs are 130 to 134. It's a similar effect as Hilmy, and again one sees that UBAF was not cited, not referred to by the tribunal in Schechter. Now, if we go back, please, to authorities tab 21.
Can I just ask them,
Yes.
what's the statutory function of what is now section 44?
It's to show when execution by a company takes place, particularly of a deed, say, or similar document. What constitutes execution?
So the error in Hilmy was equating that with mere signature.
Yes. Personal signature. And section 44, as it applies to overseas companies, one sees at the bottom of this page, it's statutory instrument 2009-1917. And as the court can see from 44, subparagraph 2, a document which is signed by a person who, in accordance with the laws of the territory in which the overseas company is incorporated, is acting under the authority of the company, which is expressed in whatever form of words to be executed by the company, will suffice. And if one goes to the mortgage deed, it's supplementary bundle tab 40. Page 319. One can see from the execution page of the mortgage deed that Mr. Rajazar, Director of NTT, signed in the name, you see in the top right hand corner, in the name of NIOC, which itself signed as attorney for NIOC on the left hand side, all of which was in the presence of a witness, Mr. Byatt. You see in the left hand column. And in our submission, there's no question that this was effective execution by NTT pursuant to section 44, as it applies to English companies such as NTT. If one goes back, if one goes to authorities tab 20, see from section 44 subsection 2b that an English company can sign by a director in the presence of a witness who attests the signature. So it follows that the document we've just been looking at was effective execution by NIOC via its attorney. And certainly the land registry seemed content with the form of the execution as it accepted the registration of the mortgage deed.
Was this point canvassed below?
I don't believe this was, no.
And don't you need to show that the person is signing in accordance with the laws of the relevant territory, namely Iran?
And this morphs it. This comes into one of the respondents' notice points. In our submission, there was no dispute as to the authority of the people signing the document.
But this point wasn't an issue. So this particular point about the complying with the regulations wasn't before the
Yes,
court.
it wasn't an issue. There was no contest raised, as it were, that these were not authorised signatures, or that it wasn't a signature in accordance with the laws of Iran, for instance.
Yeah. The argument was that it wasn't sufficient, even if they were authorised, on the basis they were authorised because they were agents.
Precisely. And I'll show you when we come to the respondent's notice exactly the way the case was put to trial.
Yeah.
Can I just, why are you showing us you just put up on the screen the sort of English Incorporated Company version, but the version on which you rely is rather different and broad.
I was just showing you this for the purposes of NTT, which is an English company.
Oh, I see. But in fact, it's arguably broader.
It's well. So there are two questions. First of all, was there a valid signature by NIOC, and we submit there was under the statutory instrument. Second question, was there a valid signature by NTT? Yes, there was, by reference to the Companies Act. And we say that it's implicit in the judge's findings if we take paragraph 116, his judgment at Core Bundle, tab 15, page 187. Just by way of example, the judge makes the same point in a number of places, but you'll see the judge finds that the mortgage deed was executed by NIOC acting by its attorney NTT. Mortgage was signed by Mr. Ragazar in the name of NIOC, in the name of NTT, as the authorised signatory of NTT in the presence of Mr. Bayat as witness. And we've seen the execution blocks on the mortgage deed. And the judge didn't make separate findings on Iranian law because no one suggested to him that this would produce a result. There was no challenge to any of these agents being authorised to sign. It's implicit in the judge's findings in our submission that the execution of the deed by Mr. Ragazar in the name of NTT was execution by NIOC. And because the signature was witnessed, NIOC also complied with Section 74 of the Law of Property Act 1925. We can just look at that briefly, which is Authorities, tab 10, page 1. And if my lords and my lady could look at subsection 4, the bottom of that page, and I think over the page.
Yeah.
So that's in terms of, can we just go back? A corporation aggregate, which I assume you're referring to NTT, here, applied to these facts, is authorised to convey any interest in property.
Yes.
Isn't there an issue about whether NTT was so authorised?
Yes, I mean it's a point I'll come to in other contexts as to whether that did that was relevant. My point is simply there is an alternative route in addition to Section 44, which arguably was complied with. But just to be clear, we don't need to comply with both Section 74, subsection 4 of the Law of Property Act and Section 44 of the Companies Act as applied to overseas.
Well,
either will do.
Well, in fact, you say you've got three. You've got UBAF, you've
Yeah.
got Section 44,
Yes.
saying
My primary point is UBAF, but there are alternative means of reaching the same conclusion. Now, as I understand CGC's skeleton at paragraph 69 to 75, they don't appear to dispute that compliance with section 44 or section 74 of the LPA would be sufficient to sign a document for the purposes of section 53(1)(b. Their only answer seems to be the assertion about proof of authority. An issue they raised by way of respondents' notice. Point not made at trial, and we say is wrong for reasons which I'll deal with separately. Well, those, my lady, those are the points on ground 2 of the appeal that we make. So if I may, I'm going to turn to ground 3. And if we just look at the judgment, it's paragraph 212, judgment below, core bundle tab 15, page 203. Paragraph 212, see the judge is finding that this case involves a trustee and beneficiary seeking to enforce a trust against a third-party creditor of the trustee. And in our submission, that conclusion is wrong, and the question of enforcement does not arise as between NIOC and CGC. It raises the question of what's meant by enforcement, which I will come to in a moment. And just to deal with the forensic point made by CGC before getting into the meat of it, they erect a straw man argument at paragraph 79 of their skeleton. It's called bundle tab 9, page 125. You see it said in the second line that NIOC's proposition is that a debtor can make or pretend to make an oral unevidenced declaration of trust over its land, then wait and see if the creditor successfully pursues it. If so, it can rely upon the unevidenced declaration of trust to defeat the creditor's claim, and if not, it can retain its land free of any trust. With respect, that is not NIOC's case. Even on this deliberately high-pitched hypothetical scenario, neither NIOC nor the fund is suggesting that NIOC would be able to retain its land free of any trust on an action by the beneficiary, i.e. the fund, against the trustee, i.e. NIOC. Neither NIOC nor the fund is suggesting that NIOC should be able to rely upon a declaration of trust that has not been manifested or proved in writing, and NIOC doesn't seek to do so. The declaration of trust which the judge found to have been established between NIOC and the fund was sufficiently evidenced in writing in our submission. The primary issue on this appeal is what writing was required by section 53(1)(b), and whether, if such writing did comply, this goes to, did not comply, that goes to validity of the trust itself or to its enforceability. There's no question of a pretend, oral, unevidenced declaration of trust in this case. It's not what this case is about. As cases like Gardner and Rowe show, where there is such a declaration is a question of fact, which the courts will interrogate when it's an issue between the parties to ascertain if such a declaration was in fact made. And that NIOC and the fund intended to create a trust in respect of NIOC House is not seriously or cannot seriously be in doubt. The error was as to the fund's status as a legal person at the times that some of the declarations the judge found to have been made were made. Now, in our submission, it is an abuse of language and a category error to talk of NIOC enforcing a trust by its defence to CGC's claim in these proceedings. What is meant by enforcement in this context has not been the subject of any judicial determination before, at least in this jurisdiction. In our submission, enforcement entails bringing proceedings to seek to perfect a trust by seeking an order from the court that the trustee fulfil its obligations, including to execute the trust. Relying on the existence of a trust as a defence to proceedings does not, in our submission, entail its enforcement, but simply the recognition by the court of the existence of a trust as a fact. And there is no case before this case where a third party to a trustee-beneficiary relationship has successfully invoked either Section 7 or Section 53(1)(b). And typically, in our submission, the only question of enforcement of a trust in the context of 53(1)(b) is by a beneficiary against a trustee, compelling performance of the trustee's obligations. NIOC is the sole trustee, or was the sole trustee. Since it was the person bound by the trust, they can in no sense be seen to be attempting to enforce it against anyone, least of all CGC. And typically the person in a position to enforce the trust is the beneficiary. The person against whom enforcement would typically be brought would be the trustee, i.e. NIOC. And in our submission, neither Section 7 nor its successor 53(1)(b is a statute for the protection of third-party creditors. The statute is for the protection of alleged settlors against spurious action by alleged beneficiaries. And NIOC, the relevant settlor, admits that a trust was declared in favour of the fund. There can be, in those circumstances, no question of enforcement of the trust by NIOC or the fund vis-à-vis CGC. And the trust in favour of NIOC House was perfected upon NIOC's transfer of the subject matter of the trust to the fund in the form of the transfer. Thereafter, there could be no question of enforcement of that trust, and there is now no trust left to enforce. Now, I said there's no decided case in this jurisdiction, but in our submission, the court can be assisted by jurisdiction from the United States, in which it's clear that, broadly speaking, the statute of frauds, which was followed, which has been applied in America, it is for the protection of persons alleged to be trustees and their successors in title, not for the protection of third-party creditors. And in my submission, the court will be assisted by looking at some of the material on the position in the United States. If I can take the court first to Scott and Asher, which is the leading US textbook on trusts. It's authorities 177.
What's the PDF for that?
I'm sorry.
177.
Supplemental authorities.
No, supplemental.
It's in the supplemental authorities.
I've got those.
Fund.
Scott and Asher. Okay.
You have it.
Right.
I'm obliged.
Okay.
And you'll see Scott and Asher on the screen, and if we could look at paragraph 6.1 1, page 31 in the PDF, you'll see that the editors deal with the position.
What are we looking at?
Paragraph 6.1.
I think what we've got is the title page. I think
We
need
should,
next
sorry,
page.
my fault. Should be
Okay.
at page 3. So in the left-hand column, I don't need to spend time on this. It looks at the background in England, and then if we go to the right-hand side,
I'm going to have to move it across the page.
you could move. Thank you. See that the authors talk about the statute of frauds in England, and then see shortly after enactment of the statute, the courts began to construe it, and they continue to this day in most states to construe its successors. As a result, there's an immense body of case law, and he says that developed something like they say it's developed something like a common law with respect to the requirement of a writing, so that the exact wording of the statute at hand is sometimes less important than one might expect. And still talking about the position in England, the statute itself has been superseded by the LPA 1925, which uses somewhat different language. Go over the page. And then this, in the, perhaps we can blow up the left-hand side. In the United States as well, courts sometimes still follow the early English decisions, even when the language of the relevant statutes differs from that of the original English statute. Which you'll see the English courts held, notwithstanding the statute, it's possible to create a trust of land orally, but sufficient for its enforcement that a writing be signed subsequently. The statute required merely that the declaration or creation of trust be manifested and proved by a writing. Even in states in which there are statutes that by their terms require a writing, creation of a trust, the courts have often followed these cases. The typical American statute of frauds requires a writing not only when the owner of an interest in land declares himself or herself trustee of it, but also when the owner transfers it during life to another as trustee. You'll see the beginning of the following paragraph. The purpose of the statute of frauds is to prevent false claims by putative beneficiary. And then if we go to the right-hand, bottom of the right-hand column, it deals with the they deal with the American statutes. Most states by statute require a writing for the creation of a trust of real property. Many of these states borrow the language, and then if we go over the page, of the English statute of frauds. In others, the language differs, but in general, the effect is the same. And then I want to go on, if I may, to page 6 of this extract. And starting on the left-hand column, section 6.14, who can take advantage of a failure to comply with statute of frauds? You'll see the learned editors say the statute of frauds does not treat an oral trust of land as void, but merely as unenforceable as an express trust. Trustees cannot be compelled to perform the intended express trust, nor can any person succeeding to the trustee's interests. Other persons, however, cannot take advantage of the unenforceability of the trust. A similar rule, and then we look over the page, applies to oral contracts for the sale of land. Thus, as we have seen, if land is transferred upon oral trust, individual creditors of the trustee, though they have attached the property, cannot rely on the unenforceability of the trust. And if the trustee performs the trust by transferring the property to the beneficiary, the trustee's creditors cannot set aside the conveyance as fraudulent.
So that's a matter of US law.
Yes.
In English law, what can the putative trustee do with the property unless and until there is a sufficient writing to satisfy section 53(1)(b)?
he can, in honour, I'll come to this, he can in honour comply with the oral trust.
Yes, but can he in honour sell it to someone else? Can he dispose of it?
No, because that would not be, well, it depends, but that might well be a fraud on the creditors.
On the creditors?
Yes.
Well, what if he sells it for full value?
Then there may be a debate. My point at the moment is simply that satisfaction of an unenforceable oral, say, let's take an oral trust by way of example, that is not impeachable by a third-party creditor, which is the point we're presently on.
Yes, we may be at cross purposes, just to reiterate the point. I've declared a trust already in favour of someone else. There's no writing to satisfy section 53(1)(b), so it can't be enforced by that person against me. Can I dispose of that property to someone else freely?
Certainly one can honour the oral trust
No, it's not the question.
and comply with the trust and transfer the property to the beneficiary of the
That's
trust.
not the question my lord's asking with respect. It's the other way around. I mean, we follow that point. If there's an oral trust, there's nothing in writing. So the trust is unenforceable by the beneficiary against the trustee. Right?
Yes.
So is there anything to prevent the trustee in that example from selling the property to a third party? Not to the beneficiary, but to somebody completely different.
Can I come back to that? Not a point I've thought about, but I take my lord's point. Can I have a think about that?
I mean, there's a separate question as to whether if the trustee, having an oral seeks to honour the oral trust by transferring the property to the beneficiary, then, I mean, in the real world, that's not going to happen without there being something in writing, which then becomes satisfies the terms of section 53(1)(b) on Gardner and Rowe. So if there's an oral trust, and then 5 years later the trustee suddenly wakes up and decides that he's going to transfer the property to the beneficiary as was promised in the oral trust, then if it's real property, he's not going to do it simply by ringing him up and saying, "I'm going to transfer this property to you."
No, but the question is, I guess, is what if there is non-compliant writing? And that's probably a more realistic scenario. If the point I'm on at the moment is if the trustee honours his obligations under an oral trust, it's not impugnable by a third-party creditor, for example, because he's complied with a moral obligation. It's a point I want to come to in relation to the trust. And can I just complete this before I come back to that point by showing the court the other text on US trust law, which is Bogart's law of trust, which is another leading text on US law of trusts. If we could go, please, it's supplemental tab 176. Supplemental authorities tab 176. You'll see, just taking this in sequence, the court will see reference to the English statute, the first paragraph, and you'll see the editors say that in the United States today, most states have statute descended from the English statute of frauds that require written evidence for trusts of in land to be enforceable. And then if we go over the page, see, so that most states have enacted some form of statute of frauds that deal specifically with trusts. The majority of those statutes closely track the 7th section of the English statute and apply to trusts in land only. A significant minority of states have statute of frauds that apply to all express trusts in both real and personal property. And then can I please go to page 4 of this extract? And then rather than reading it out, could I ask the court please to read this page on the screen at the moment, and then just over the page when you get there. And I just, over the page, I think you just need to read to the end of the first paragraph.
Yeah.
So I was just going to take the court to a couple of illustrative examples of this principle in operation by reference to the US cases. If we could go first to Watson and Willison, which is in the same bundle at tab 175. If I can just summarise the basic facts, a debtor transferred land to be held on trust for certain of his creditors, and the trustee then sought to sell the land. One of the debtor's creditors objected on various grounds. Amongst other grounds, she complained that the trust was void because it didn't comply with Section 9 of the Illinois Statute of Frauds. And you can see that set out at page 7 of this extract. See Section 9, at the bottom of the page, Section 9 provides that all declarations or creations of trust or confidences in any land, tenements and hereditaments shall be manifested and proved by some writing signed by the party who is by law enabled to declare such trust, or by his last will in writing, or else they shall be utterly void and of no effect. So very faithful to the original 1677 English statute. And if we go on to page 11, it was held by the Illinois Appeal Court that the creditor could not rely upon the statute of frauds. You'll see, we go 5 lines down, the defence of the statute of frauds was available to the appellee, the deed being an absolute transfer of the property to him. But the appellee, having waived it by his declaration of trust in the bill of complaint, is not available to any party who is not a party to the trust agreement. The purpose of the statute of frauds requiring express trust to be manifested or proved in writing is for the benefit of those claiming title under the deeds or other instruments absolute on their face, and not for the benefit of those seeking to defeat the operation of such a deed. Where the trustee does not plead the statute of frauds, it's waived by the trustee, and no other party to the suit can insist on the statute as against their adversaries. And then finally, a Californian case, we go to Cardoza and White, which is at tab 174. Just by way of summary, the background facts, so far as relevant, are that one Nunez transferred land to Callahan to hold on trust for another party, Cardoza. Callahan subsequently transferred the land to Cardoza, and a creditor of Nunez attempted to seize the land in satisfaction of Nunez's debt. The creditor argued that Callahan could not have held the land on effective trust for Cardoza owing to non-compliance with the Californian statute of frauds. And that argument was dismissed by the court. And we can see at page 2, if you look in the bottom right-hand corner at paragraph 3, what Justice Langdon says is defendants argued that the transaction cannot be upheld because while the deed was in writing, the agreement constituting the trust was oral and hence violative of the statute of frauds. But an oral trust in real property cannot be held wholly void. It's merely unenforceable when in an action brought to compel performance of its terms, the party to be charged asserts its invalidity. Callahan, the party obligated, did not refuse to recognise the trust. On the contrary, carried out its terms. A creditor of the trust store has no right to challenge. Trustee has no right to challenge the voluntary completed performance by a trustee in such a situation. Indeed, if Callahan had repudiated his obligation, plaintiff as the intended beneficiary could have held him as constructive trustee for her benefit, which I think may at least in part answer my Lord Justice Zacaroli's question.
Yes.
But also it might well arise under English law, a constructive trust, on that type of fact pattern. So, for example, in Rochefoucauld and Bausted, and Bannister and cases like that. And we do submit that this is consistent with this approach we see in the US cases is consistent with the English case of Dawson and Ellis, which is at authorities tab 37. And which we refer to in our supplementary skeleton. And just to try and summarise, in this case, Mr. Ellis contracted to sell land to the Duke of Norfolk, but the contract was not recorded in writing, such that it was unenforceable pursuant to, in this case, Section 4 of the Statute of Frauds. Subsequently, Mr. Ellis contracted in writing to sell the land to Mr. Dawson, He then conveyed the land to the Duke of Norfolk, who had notice of the contract with Mr. Dawson, and Mr. Dawson sued for conveyance of the land to him, pursuant to his contract. Now, just to point out that CGC are right to have corrected us in their supplementary skeleton, paragraph 25. On the facts, it was found that there was no contract between the Duke of Norfolk and Mr. Ellis, such that Mr. Dawson's action succeeded. But the Master of the Rolls regarded it as correctly conceded that had the contract existed, it would have been first in time and binding on the conscience of Mr. Ellis, such that the Duke would have been entitled to retain the land. And one can see the argument if we go to the second page of the report. You see 4 lines down the argument for the defendant Ellis and for the Duke of Norfolk, and see a few lines down, it says, originally before the statute of frauds, all parole contracts, whether written or verbal, were of equally high authority, and the preference must have depended simply on the dates. Now the words of the statute are only negative. A verbal contract cannot now support a suit or action, but for every other purpose it remains the same as before. May be used for defensive purposes, and this court still considers as equally binding on the conscience of the parties. Ellis was therefore bound in conscience to complete the first in preference to the second contract, and the Duke, having now the legal estate, cannot be deprived of it, for though he took it with notice, yet it was only notice of an equity to which his own was preferable, so long as he did not appear in the character of a plaintiff. And then you'll see Mr. Trower in reply admitted the doctrine contended for on the other side and relied solely on the evidence, not establishing any pre-existing contract between the defendants. And then you'll see that the Master of the Rolls thought that the point made by the defendant's counsel had been rightly conceded. The question was therefore one of fact only, viz. Whether the treaty between Ellis and the Duke of Norfolk had ripened into a contract or not. After going through the evidence, he arrived at the conclusion that it had rested only in treaty and that no actual agreement had been made. He therefore decreed a specific performance and a conveyance for the plaintiff, Mr. Dawson. Now, I accept that that is obiter and based upon a concession by the claimant, but it shows that the English court, like the US courts, regards performance of obligations which are unenforceable by reason of non-compliance with the statute of frauds as nevertheless binding upon the conscience of the obligor in priority to third-party claims.
Can I just, as I understand your ground 3, this is if you don't succeed on either of ground 1 or ground 2, just don't need 53(1)(b) isn't in point at all, is what you're saying. You've got to apply that in the context of the Insolvency Act provisions, don't you? It's not, and that when you look at the interpretation of that provision, it may not be a question simply of who would have the better title. Just think of it this way: if there is an oral declaration of trust, and this goes to my Lord's earlier question as well, there's an earlier oral declaration of trust. The putative trustee there hasn't yet been any writing that evidences it, so it's unenforceable.
Not by the beneficiary.
By the beneficiary. Therefore, on the face of it, the trustee, let's assume there are no creditors around, the trustee appears to still have a valuable asset. Because unless he either signs something or perhaps authorises someone to do it, but signs something, that trust is not perfected, cannot be relied on by the beneficiary. So if at a time when his solvency might be threatened, for example, he produces a piece of paper, appears to me that he's now got fewer assets than he previously had.
I take my lady's point. And in our submission, the prior moral obligation under the unenforceable trust would take priority, so that there would be no offence in relation to the insolvency legislation, because the trustee would be honouring the moral obligation as trustee.
Does that go to the defence of no purpose rather than the defence of no transaction?
Yes.
But
Okay.
would you accept there's a transaction? Merely signing a piece of paper recognising the existence of a trust would be a transaction potentially within 423.
It could be. It could be. What the court would have to do is to ascertain whether there was genuinely obviously the court would be astute not to find too readily that there was a prior oral declaration of trust allowing the insolvency legislation to be sidestepped. But if the court was satisfied that there was a genuine declaration of trust beforehand, and the trustee then complies with it, we see the references to the moral obligations in Bogut's, I showed the court the extract of, and in Dawson and Ellis, then that would be a trust still binding on the conscience of the trustee, and he would be entitled to perfect the trust and the purpose would not be to avoid the insolvency legislation. The purpose would be to comply with his obligation under the trust.
Isn't that your client says was their position here? They believed there was a trust and they believed they were merely perfecting it, so they had no purpose, but the judge found you did have a purpose and there's no appeal against that.
Yes, the paper is not a transaction. It is merely the creation of evidence which didn't exist beforehand, the signed paper.
I understand that, but ultimately this is a question of the interpretation of section 423. Not a question of which equity takes priority in that sense. It's a question, might be seen as a question of, is the debtor doing something to put his asset out of the reach of creditors? And of course, we don't think we've been provided with it, but we've got recent Supreme Court authority on what the purpose of section 423 is. I assume maybe someone will take us to that at some point. And if you produce a piece of paper, or here, relevant, if there's been no writing beforehand because you've lost on the other grounds, we've got the transfer of the legal title, which you might say perfects the trust. But the question is still whether that action puts assets beyond the reach of creditors. If no document was ever produced and the legal transfer hadn't happened, wouldn't NIOC House be available to creditors?
In that scenario, yes. Looking at the authorities I've taken, my ladies, it would not be available to a third party to the trust relationship to interfere with the trust obligation if it was perfected, as long as the court was satisfied that there was a genuine oral declaration of trust beforehand. And if that is the case, then in our respectful submission, there is no avoidance purpose.
Well, it goes back to the purpose, but I think your previous answer was there's no transaction if all you do is sign a piece of paper. The section requires entering into a transaction with another person. You might say that's not, can't be covered by merely signing a piece of paper and evidencing something that's already happened.
Exactly. The transaction, there's no transaction which has an avoidance purpose. It's merely providing evidence which complies with section 53(1)(b).
I'm confused then, because I thought this ground is if you fail to succeed on the other grounds, so you haven't got pieces of paper from 2019 on which you can rely. All you would have in that scenario is the actual transfer of the legal title, which is a transaction which the judge found was undermined by.
No, for the purpose of this argument, I'm assuming that there is a non-compliant trust.
Yes, but you haven't perfected it.
Which hasn't been transferred, hasn't been
So
perfected.
there isn't a piece of you can't rely on there being a piece of paper that isn't a transaction, because on this particular scenario, the only piece of paper you have is the actual transfer.
Well, in our submission, the piece of paper would be writing, which complies with section 53(1)(b), and that is simply evidence. The prior oral declaration of trust or the non-compliant writing would be the relevant transaction, and that would not be entered into for an avoidance purpose.
Just to go back to something else you said, because the US authorities would seem to help you here, but you've mentioned Rushvukal, which, I mean, the question is, does the trustee have the free disposal of the asset which he's holding on a trust, which so far hasn't been evidenced in writing? If he transfers to somebody who has knowledge of that trust, then that might not be a valid transfer.
Might not be under the principle in Rochefoucauld, it may not be, because what Rochefoucauld holds is that the statute of frauds won't be used as effectively as a means of committing a fraud. You can't hide behind the non-existence of the written evidence to breach your oral declaration of trust.
So that would suggest that maybe the property isn't a free disposal of the trustee if that principle is right.
Yes, I can see that point. Other than by way of transfer to the beneficiary. And it's not a transaction at an undervalue, because one has been released from your trust obligations. And in those circumstances, there is no, CGC is not, we would submit, a victim.
Is that a convenient moment to have a break?
Yes, my lord, it is.
So, just before 20 past on that clock, we break. Thank you.
Rise.
Yeah, absolutely.
Yeah, that's just
Yeah. It's all the same question. Yes. It's a good one. Anyone need water?
Well, the transaction is a transfer. Transfer the beneficiary.
All rise if able.
You'll all appreciate they're not yet back in.
So they're not back in. Sorry, I didn't notice. Don't worry, don't worry. Sometimes I think we should have a bell, actually. Trouble is, if we had a bell, we'd also have to have a red light system, wouldn't we, like that in the United States. Well, I tell you what we do, we'll rise again if somebody could go and scour the highways and byways and see whether they are.
We'll send a committee of us.
Court rise.
Get the us to come and get us. You've got to look it up.
Did you let them know? All rise if able.
I was going to turn to one Commonwealth authority which might assist the court, and then if I may, I'll come back to my lady's question
Of course.
at ground 7, right at the end. It's a New Zealand case, which is Commissioner A and the Commissioner of the Inland Revenue. It's Authorities tab 62. PDF 1269. We refer to this in our supplementary skeleton at paragraph 28. It's a dispute with the tax authorities over input tax, and the basic relevant facts the court will see at page 3 of this report. One could, if the court could just look at paragraphs 15 to 16. And then if we go to page 5, you'll see that the issue is identified at paragraph 36, at the bottom of the page. And just for my for the court's note, the New Zealand Property Law Act of 1925 is in identical terms to our 1925 Act, and you see that from page 14. 1952, sorry, Property Law Act 1952, and you'll see at the top of the page section 49A set out. You'll see subsection 2 is in the same terms as subsection B. And Judge Willie held at paragraph 63, which is on page 14, begins at page 14, beginning in paragraph 63, and then he sets out a number of authorities there and then over the page. And then you'll see in the middle of the page, it says a third party to the transaction creating the trust, such as the Commissioner of Inland Revenue, cannot be heard to rely on section 49A to defeat a trust which the disputant not only regarded throughout as binding on him, but which he has perfected. The effect of allowing such an outcome would be a side wind defeat the interests of the beneficiaries and vest the land in Mr. A strange and unjust result. Now, CGC's criticism in connection with this authority we say is misplaced. The judgment of the judge does not as they suggest, paragraph 23 of their supplementary skeleton, stand for the proposition that a third party creditor cannot rely on section 53(1)(b) to defeat a trust which the disputant regarded throughout as binding on him and which he has subsequently perfected. And they suggest perfected there means through satisfying the writing requirement. And with respect, that's not what perfecting a trust means. The trust was not perfected by Mr. A satisfying the writing requirement, but by the transfer of land to the beneficiaries, i.e. his daughters. You can see that if we go back to paragraphs 52 and 55 of the judgment at page 13. You see at 52, the judge deals with background facts, and then at 55, as soon as Mr. A was able to, he did transfer the land to the trust through the medium of the company. I have no doubt at all that he regarded himself as holding that the land on trust for the benefit of his daughters. And I say that's obiter because he went on to find a paragraph 64 at page 15 onwards. 64 through to 67, we don't need to dwell on it, but he went on to find there was in any event sufficient writing. But when the judge spoke of perfection, he meant performance of the trust obligations, which Mr. A considered he was bound by.
And that was by the actual transfer of property.
Yes. And we say that prior to execution of the trust in respect of NIOC House by the transfer, the trust was binding upon NIOC's conscience, such that it could not have transferred it to CGC in satisfaction of the judgment debt, nor to any other third party other than the fund. And we say CGC is wrong to say that the transfer was voluntary. In our submission, it was not. NIOC was not making a gift to the fund, it was transferring to the fund property which already belonged to it in equity, irrespective of the formal requirements of section 53(1)(b). Valid trust, simply unenforceable by the fund, unless and until NIOC decided to comply with the prior trust.
Can it really be said that the property belonged to it in equity if the trust was unenforceable by it?
Yes, so
If the legal ownership is with NIOC and the trust is unenforceable on this type of trust, how can it be said that the beneficial interest is owned in equity by?
at least so far as the conscience of NIOC.
Well, that's a different
concerned,
point.
Yes.
The point about conscience is a different point.
It was
And
on,
that seems to be what Judge Willey decided in this case, at paragraph 55, that Mr. A regarded himself as holding the property on trust to the daughters, which is, he'd made the transfer. And you would say, well, if NIOC were to, if NIOC transferred to the fund, but believing that it was under a moral obligation to do so, then that's sufficient for the fund to obtain ownership. Is that the point?
yes, that's the point.
Good. Okay.
And if, in our submission, just turning briefly to ground 7, if the court is with us on grounds 1 to 3, in my submission it follows that the appellants should succeed on ground 7 as well. As observed by Lord Justice Mayles, this ground is parasitic on the other grounds. If the appeal succeeds on any grounds 1 to 3, the justification for making the order under section 423 falls away, as Lord Justice Mayles put it in giving permission. And in short, in circumstances in which the transfer of NIOC House was to give effect to a trust obligation, a Section 423 order in CGC's favour was inappropriate for three reasons. First of all, NIOC had no beneficial interest in NIOC House, and so CGC was not a victim of the transfer. Secondly, the transfer was not at an undervalue. NIOC received consideration in the form of its release from its obligations as trustee, and in any event, distribution of property held on a bare trust to the beneficiary of that trust cannot properly be characterised as a gift or a transaction on terms so as to bring it into the scope of Section 423. And thirdly, and in any event, allowing CGC to enforce a judgment debt owed by NIOC against property which belonged to the fund, in our submission would be inappropriate. Whether or not the trust was enforceable, the fact remains that NIOC itself had no beneficial interest in the property, and so CGC was not a victim. Whether or not the trust was enforceable, the transfer can't be described as voluntary, and we saw that in the US materials we looked at, and I'll come back to Gardner and Rowe as well in this context, in the respondents' notice issues. And it wasn't a gift, it wasn't on terms that provide for no consideration, or as taking place at an undervalue. NIOC was complying with a prior moral obligation and releasing itself from its obligations, albeit unenforceable obligations, as a trustee. Well, that's all I have to say on ground 3.
Right.
And it's related to the points we make on respondents' notice point 1, which is addresses the consequence of non-compliance with Section 53(1)(b), whether it's a question of invalidity or unenforceability. So if I can turn to that topic next. And I'll deal with the arguments in respect of the first respondent's notice points in the following order. First, the conventional view of the law and the authorities supports NIOC's position and undermines CGC's position. Secondly, a brief return to the legislative history, which again is consistent with NIOC's position. And thirdly, following on from that, the significance of the meaning of the words manifested and proved in Section 53(1)(b), which I think I can take very shortly because Mr. Grant has substantially dealt with it. Now, as CGC accepts in its skeleton at paragraph 80, the common and perhaps orthodox view is that non-compliance with Section 53(1)(b) renders a trust unenforceable rather than void. And that's the view reflected in the leading academic textbooks cited by the judge at paragraphs 202 to 206 of the judgment. I won't take time on going through the materials. I'll just give the court some references where we could see the judgment at Core Bundle tab 15, page 202. You'll see the judge sets out various extracts from the text, and I'm just going to give the court the references to the bundle, if I may, to those texts. So Snell, paragraph 203, is at Authorities, tab 169, page 6, PDF, page 3357. Thomas and Hudson is at Authorities, it's paragraph 512 at Authorities, tab 141, page 2, PDF 2903. Underhill and Hayton at paragraph 4.14.14 is at authorities tab 158 page 9 PDF page 3206, and Lewin on trusts is at authorities tab 163 page 5 PDF 3261.
Mr. Thank you. We're on the respondent's notice now, did you say?
Yes.
Which point on the respondent's notice?
It's at point 1 under the respondent's notice, the consequences of non-compliance with 53(1)(b). The dispute between us is that Mr. McQuater says that the consequence of non-compliance with 53(1)(b) is that there is no valid trust at all.
Yeah, I thought this was ground 3, but I must be confused.
Well, it overlaps with ground 3, and I assumed I was correct in making the arguments under ground 3, but I'm now dealing with the substance of the point, which arises under respondent's notice, point 1. I apologise, my lord, I should perhaps have taken it in the other order, but
That's all right.
my lord, just to complete the picture, can I show the court just a few other references? I've shown the court Professor Virgo, I think, already at authorities tab 164 page 2. Just look briefly at Jacob's Law of Trusts in Australia. You've seen the Conveyancing Act of 1919 already. It's authorities 147, tab 147, page 39. The court could just read subparagraph 3 on this at the top of this page. Sorry, the PDF is 2969, I'm sorry.
This all comes back to Gardner and Rowe, doesn't it?
Yes.
I mean, Snell, I just looked at Snell. Snell actually cites Gardner and Rowe at this point, and as does this text. The point being that if it were invalid, and like void in some way, the subsequent rating, particularly after
The bankruptcy.
couldn't have saved the trust that it did. So it has to be unenforceable as opposed to invalid.
Indeed, and it's been followed in a number of cases, which I'll show the court. And then if I can just give the court some more references without turning them up. There's Hayton on the Law of Trusts, authorities 138, page 2, tab 138, page 2, and 2877 is the PDF reference. And then Cheshire and Byrne at tab 143, page 2, PDF 2912. And we do add that the legislative history is at odds with CGC's argument. We've already looked at this in relation to ground 1 and set out the relevant legislative background in our supplementary skeleton at paragraph 37. The key point the court already has that section 7 of the Statute of Frauds expressly provided for a consequence in the event of non-compliance with its formality requirements, namely the purported declaration or creation of trust would be utterly void and of no effect. And notwithstanding that provision in section 7, it's consistently been interpreted to mean that the trust of the land needed only to be evidenced in writing, and that failure to comply with the requirement of section 7 had the result that the trust was valid but unenforceable. And my Lord the Chancellor is familiar with Gardner and Rowe. Would it assist if we just looked at Gardner and Rowe briefly? It's Authorities tab 50. PDF 901. By way of very brief summary, the salient facts are these: that on the 23rd of January 1812, Mr. Wilkinson took a lease of a mine. On the 23rd of August 1813, he executed a deed declaring that he was trustee of the lease for Mr. Rowe. However, in the intervening period, he committed an act of bankruptcy, and one can see that all in the first paragraph in the headnote at page 1 in the extract. Mr. Rowe argued successfully that Mr. Wilkinson took the lease of the mine as trustee for Mr. Rowe. And we can take up the judgment of the Vice-Chancellor, beginning internal page reference 351 at page 3 of this document. And we can see from this see the facts summarised in the first paragraph, and then if we go to the last paragraph on the page, the question which has now been mainly argued before me is whether the indenture of the 24th of August 1813, having been executed by the bankrupt subsequent to his bankruptcy, can or not be received as against his assignee as a declaration of trust in writing. And then if we look at the bottom of the page, 3 lines at the bottom, this deed therefore in respect, and I emphasise this deed therefore in respect to the moral obligation of the trustee to give effect to his trust, would not in such a case have been considered as a mere voluntary deed. And I do pray and aid those words at the bottom of page 3. If in respect of the moral obligation affecting the trustee, this declaration of trust would have prevailed against the assignees if executed the day before the bankruptcy without any other consideration, I cannot find a principle why it should not prevail against the assignees if executed the day after the bankruptcy, especially when it's considered that a trust does not pass by assignment in the bankruptcy. The reasons I'm of the opinion that the indenture of the 24th of August, though executed after the bankruptcy, is a good declaration of trust in favour of Rowe within the statute of frauds. So we can see from this judgment, the trust was not void because it had not been manifested in writing at the time of its declaration. Rather, it was capable of taking effect despite the lack of contemporaneous writing manifesting it. And from the time of its declaration, there was, as we see at the bottom of page 3, a moral obligation on the trustee to give effect to his trust. It's not disputed that this deed of August 1813 would have prevailed against the assignees as a declaration of trust if it had been executed over the page, been executed before the bankruptcy. Yet a mere voluntary deed executed before the bankruptcy will not prevail against the assignees. This deed, therefore, in respect to the moral obligation of the trustee to give effect to his trust, would not in such a case have been considered as a mere voluntary deed. And I emphasise that. Obviously, the Vice-Chancellor went on to say that whether the deed had been signed before or after the bankruptcy, a trust does not pass by assignment in the bankruptcy, you see from the top of page 4. So we do place reliance on the Vice-Chancellor's reference to the moral obligation of the trustee to give effect to his trust, and giving effect to the trust not being voluntary. That analysis is consistent with the US position we have seen, for example, in Bogarts.
Can I just ask, quite a few of the texts you've taken us to, including some of the English ones cited by the judge, expressly say that if the writing after the declaration of trust, if there is writing, it then takes retrospective effect. Would you say that is presumably, you would say, implicit in this case? I'm not sure we've been taken to other English cases.
I'm about to.
You are?
I'm about to go, which makes that crystal clear. But yes, I think it's. My lady is right. It is implicit in this judgment, but I'll show my lady clearer cases which make that point in terms. We say that the analysis, we can see a reflection of it in the US position. For example, Bogarts Law Trusts.
Leaving Gardner and Rowe now.
Yes.
Do you not get something from the appeal decision?
Yeah, you do. Actually, on that point that my lady just asked about,
Yeah.
if you go to the next tab, you'll see the
Yes, in the Lord Chancellor's.
Lord Chancellor's judgment. I can't help noticing, as I think I pointed out to my colleagues, in a modern context, that the Lord Chancellor took 11 months to produce a judgment on this hypothesis, which was 4 paragraphs long. Shades of bleak house, I feel. But doesn't that help? Really, it's the second paragraph. It's 262, isn't it?
Yes, indeed.
That property held in trust is not the property of the bankrupt. So it's predicated on there being a valid trust, even if it's not enforceable.
Precisely.
So the property hasn't transferred.
Yes, and you see that in the Vice Chancellor's judgment too, that the property doesn't transfer upon the bankruptcy.
Yeah.
So it's of a piece.
Yeah.
But my lord is right. Indeed, the Lord Chancellor's judgment there is even clearer than the Vice Chancellor on that point. And we say that it's also consistent not just with the US position we saw, but the Dawson and Ellis case we looked at earlier, where an unenforceable obligation in contract was similarly seen as binding on the conscience of Mr. Ellis, the contracting party. And then to deal with my lady's question, could we look at Forster and Hale, which is Authorities 45. PDF 800. The facts are quite convoluted, but if we could just go, please, to page 6. It's the bottom of the page. If the court could look at paragraph beginning that, I certainly admit, in the judgment of the Master of the Rolls. then if we look in the next tab at 46,
Appeal.
this is in the judgment of the Lord Chancellor, Lord Loughborough. If we go to page 4, and you just see, just in the middle of the page, that he says, "I perfectly agree with the Master of the Rolls in adopting the letter of Mr. Burton as a clear declaration of trust." When I say that, I mean clear evidence in writing that there was a trust. It's not necessary that it should be a declaration, that a writing signed by the party may be evidence of a trust admitted in that writing signed by him. And then if we could, my lady will see it, you see the reference to evidence in writing that there was a trust. And then if we look at Rochefoucauld and Bousted, which is the authority tab 107, PDF 2216, good. Page 11. You see in the judgment judgment of the court delivered by Lord Justice Lindley, but you see it's the judgment of the court which included Lord Halsbury and Lord Justice A.L. Smith. Page 11 at the top of the page, it's not necessary that the trust should have been declared by such writing in the first instance. It's sufficient if the trust can be proved by some writing signed by the defendant, and the date of the writing is immaterial. Just for reference, another case which shows that the trust is effective retrospectively is Ambrose and Ambrose, which we deal with at paragraph 37(3)(a) of our supplemental skeleton at core bundle 25, page 345, but I'm not going to spend time turning that up now.
Do not rely on the next sentence as well. Yeah.
Indeed.
This is further established.
Although that is a different factual situation.
It's a different factual situation.
It's not self-declaration and then going back on your word.
It's a conveyance upon an oral declaration of
Yes,
trust.
which is different.
Which is different. I'm not saying that the point is precisely analogous.
So which sentence are you referring to there? Consequently. Because the one
Yes.
before that seems to be a broader application. It is further established by a series of cases the propriety of which cannot be questioned. Statutory fraud does not prevent the proof of fraud. It's a fraud on the part of the person to whom land is conveyed. I see.
It's that passage.
Well, yeah. Does it make a difference that it's conveyed rather than
Well, in principle, quite possibly not.
Gardner and road or is it conveyance?
The difference is this, if they're getting here at a situation where someone never owned the property beneficially, it was conveyed to them on the understanding that they would act as trustee. That is qualitatively different to I own a property and I do have beneficial title to it and I make an oral declaration.
I would accept it's qualitatively different, and one can see that there are possible analogies, but Rochefoucauld has been analysed as a case which deals with a situation where you convey land on the basis of an oral declaration of trust, and in those circumstances you can't hide behind the statute to say, well, you can't prove the oral declaration because there's no document complying with section 53. For the reason that the court gives in this case, which is the statute of frauds won't be permitted to be used as an instrument of fraud
Yes,
itself.
but
It's quite
that's
striking
because
that in
it's
case they go on to deal with Bartlett and Pickersgill, where what seems to have happened is that the court decided that the defendant was guilty of perjury, and he was convicted of perjury, even though the court couldn't actually enforce the trust in favour of the plaintiff because there wasn't a declaration, there wasn't evidence in writing, presumably.
Yes, I think that looks correct. And as we've seen, the crucial change from section 7 to 53(1)(b) is the removal of the prescription shall be utterly void and of none effect. And in our submission, the obvious conclusion is that Parliament intended 53(1)(b) to reflect the position accepted by the courts in the case law on section 7, namely that despite the prior inclusion of that wording, in fact, the consequence of the failure to comply with the formalities didn't result in the trust being void and of no effect. And as we point out in our supplementary skeleton, what we see is CGC effectively straining to argue against the proposition based on an article by Dr. Wilde. Dr. David Wilde is an academic at the University of Reading who argues that the dominant view is wrong and that the effect of non-compliance is that no trust comes into being at all. And that is, with respect, not the position on the authorities, nor should it be the law. And Dr. Wilde himself, in his article, recognises that the approach is a radical departure from the conventional interpretation of the statutory rule. And as we explain in our supplementary skeleton, paragraph 31, it poses a significant difficulty for CGC's argument that there are two unanimous Court of Appeal decisions which endorse, as part of their ratio, the orthodox view in effect. And Dr. Wilde is critical of both of these decisions, but even he recognises that they're binding on the court. And they're consistent with the weight of authority in the leading texts on the subject which we've been looking at. If I might turn first to Sandar and Sandar, which is at authority tab 110. And if I can, there's no head note, if I can try and summarise the facts. This was a case in which a trust of partnership land declared in favour of a company was found to be proved by subsequent communications with a bank. Mr. Sandar and three Messrs. Kang had been partners in a food wholesale business and in 1976 acquired valuable property in Birmingham, which was bought and registered in the names of the four individual partners. At some point between the acquisition of the property and 1992, a company, SKL, was formed which took over the conduct of the partnership's business. The four individuals remained throughout as the legal owners of the property, but they held it on an express trust for the company, SKL. Now, just pausing there was a dispute as to whether the property was validly transferred, in fact, to SKL in 1992, it being alleged, and we see this from paragraphs 21 and 22, it being alleged that the transfer document was a forgery, and Mr. Sandar said that that raised a triable issue. I'll come back to that in a moment, but following a falling out of the partners, Mr. Sandar sought a declaration that he had a 25% beneficial interest in the property, and SKL and Messrs. Kang resisted the claim on the basis that when the property was purchased, it was treated as part of the partnership's assets, and when the company SKL was formed, it was held by them on trust for the company, which was the beneficial owner of the property prior to the disputed transfer in 1992. Now, a series of documents were produced that showed all four of the individuals regarded the property as being held on trust for the company. And this included a Barclays charge of 1978, and that's at paragraph 15 at page 4. The Barclays charge of 1978 described the individuals as the trustees and the company as the beneficial owner. And then at paragraph 17, the NatWest mortgage from 1981, which referred to the trustees rather than the beneficial owner charging the property, and sees that at paragraph 17. So those are the two bank documents. The property was also shown in the company's statutory accounts and for tax purposes as company property. That's at paragraph 14 on page 4. And then if we go back, please, to paragraph 19. We'll see, just as in the present case, it was also the case in Sandar that the company, i.e. the beneficial owner, had received income from a tenant and had paid for maintenance of the buildings. Now, at first instance, on an application for summary judgment, the judge concluded that it was inevitable that the property belonged to the company beneficially, and that Mr. Sandar had no reasonable prospect of establishing that he had retained a 25% beneficial interest in the property. And the Court of Appeal upheld that decision. And if we look at paragraph 24 on page 6, you'll see that Lord Justice Jacob says that the alleged forged transfer in 1992 made no difference because it was clear that the company owned the building beneficially prior to the transfer under an express trust. See that in paragraph 24. And then at paragraph 25, Lord Justice Jacob says that nothing done by anybody is consistent with anything else, that is, that the property belonged to the company beneficially at the end of paragraph 24. And everything that was done is only consistent with that, as is every document from the time. And at paragraph 26, Lord Justice Jacob addressed section 53(1)(b), finding that the two bank documents, being the charges of the property with Barclays and NatWest, which postdated the acquisition of the property, clearly comply with section 53(1)(b). It's implicit that these two documents, unlike the bank statement, which is not referenced by Lord Justice Jacob here, or the statutory accounts, were appropriately signed, so that the later writing was sufficient for the purposes of section 53(1)(b), that Mr. Sandal's claim to beneficial interest in the property was unsuccessful. Now, if CGC's argument were correct, the later writing would have been insufficient to save the trust, which would have been invalid for a lack of writing ab initio. Now, Dr. Wilde criticises this decision. If we look at authorities, tab 156, I'll give my Lord Lord Justice Zacaroli a PDF in a moment. Did you have that? And then if we look, page 9, bottom of page 9, under the heading Court of Appeal Cases, Dr. Wilde refers to two decisions adopting the conventional interpretation of 53(1)(b), and he says neither is compelling. And if the court could just read to the end of, over the page, the court could just read to the end of the first paragraph, page 10. First paragraph deals with Sandal. So if the court has read the first paragraph, we say that with respect to criticisms, they're somewhat insubstantial. Said that the court's decision to regard the company acquiring its interest in the property by way of subtrust was artificial, although he is then constrained to acknowledge that it's legitimate for a court to interpret a transaction in a manner that will give effect to it rather than frustrate it. Now, the subtrust analysis doesn't appear in the Court of Appeal judgment. Dr. Wilde appears to have discerned that from the Court of Appeal's finding that no document complying with section 53(1)(c) was necessary. But it's not clear that the Court of Appeal regarded subtrust as particularly pertinent. They simply found that a distinct trust was created by the legal owners of the property to which section 53(1)(b) applied. And whether it was a freestanding trust or a declared subtrust didn't matter for the purposes of Lord Justice Jacobs' view of section 53(1)(b). Dr. Wilde also complains that it appears that leading counsel was taken by surprise by the suggestion that the bank documents complied with section 53(1)(b), but all we are told is that counsel was unable to see an answer to the suggestion at paragraph 26 of the judgment we looked at a moment ago, that section 53(1)(b) had been complied with. And finally, Dr. Wilde says that the case could have been decided on other grounds, but the fact is that it wasn't. So that's Sandar. I was going to turn then, if I may, to Ong and Ping, which is authorities tab 91. I'm afraid the headnote to the report it's very long, it's not particularly helpful, so I'll try and summarise the relevant facts from the judgment of Sir Colin Rymer, who gave the leading judgment, though it was anonymous. And you'll see paragraph 1 on page 4. He summarises the background facts and identifies the property in issue. And the case concerned a dispute between members of the Ong family over a house that we see described there. And the claimants, who were the respondents in the appeal, sought a declaration that the house was the subject of a trust created in 1986 by Madam Lim. And if you look at paragraphs 4 and 5, you'll see that Madam Lim was the mother-in-law of the first claimant and the grandmother of the other 3 claimants. And then at paragraph 6, we can see that the house was purchased by Madam Lim in January 1986. The claimants alleged that Madam Lim had declared a trust of the house in April 1986, and that after the sale of the property, the proceeds of sale became held on the same trust. You can see from paragraph 7 that the solicitors acting for Madam Lim on the purchase were Robert Gore and Co. So we can see at paragraph 7 that the judge at first instance heard oral evidence from Mr. Hyde, the partner who handled the matter. And paragraph 9, again on page 6, refers to a meeting that took place on the 14th of December 1985 between Madam Lim, her son to Joan, and her solicitor Mr. Hyde. If I could ask the court please just to read paragraph 9, bottom of page 6. And then page 7, paragraph 13, you can see that the purchase was completed on the 6th of January 1986, and the property was registered in the sole name of Madam Lim on about 1st of April 1986. Following on in paragraph 14, Madam Lim gave further instructions to her solicitor, Mr. Hyde, regarding the ownership of the house. And if we look at the top of the next page, Mr. Hyde indicated that he prepare a trust deed incorporating her instructions. Then at paragraph 16, Mr. Hyde sought advice from chartered accountants on the proposed trust, explaining that Madam Lim's intention was for the house to be occupied by her son and his wife and their 3 children, and it should be held for the benefit of the occupier and an additional child of the wife's. And then if we go please to paragraph 19 at the bottom of page 8, continues over the page. February 1986, Madam Lim's solicitor Mr. Hyde sent her a long letter, which we don't need to read the whole of, headed with the name of the property, enclosing a trust deed which bore Madam Lim's name as settlor and trustee, and naming the beneficiaries of the trust. See that from page 9, the letter is set out at some length. Now there's an issue, if we go to page 10, we can see that there is an issue about various dates of drafts, but the relevant trust document, being a draft of the 27th of February 1986, is described at paragraph 22, and it didn't refer to the house, and that's the critical point in this context. Then we see further correspondence, page 11, paragraphs 26 through to 31. And if we go to page 12, paragraph 29, we can see a query from Mr. Hyde on the 2nd of April, asking for instructions as to the land certificate for the property, which Sir Colin comes back to, we'll see in a moment. And we can see from paragraph 30 that on the 14th of April, Madam Lim said, in respect to the trust deed, I enclose here with the copy which was executed for your attention. And the document that was enclosed was signed, but still contained a blank in respect of the details of the settled property. And then if we go on bottom of page 12 to paragraph 31, on the 16th of May 1988, so 2 years later, Madam Lim wrote to another solicitor at Robert Gore and Co, Mr. Gore, referring to the property by name and informing him that she wanted to cancel the trust, dated 14th December 1985. Now the judge's decision, first instance, is set out at paragraphs on page 12, paragraphs 32 through to 38. We don't need to dwell on that rather than the Court of Appeal judgment. But you can see at paragraph 38 on page 15 that Sir Colin Rymer commented that there may have been internal inconsistencies in Mr. Justice Morgan's judgment at first instance. And then if you go on to paragraph 39, you'll see that he summarises the issues on the appeal. The first issue is whether Madam Lim made a valid declaration of trust in respect of the house. The second issue is whether, if so, whether that declaration was manifest and proved by some writing signed by her sufficient to satisfy section 53(1)(b). Now, at paragraph 59, if we can go on please to page 20, Sir Colin held that a valid declaration of trust had been made in respect of the house. And if I can invite the court to read paragraphs 59 through to 62. What you can see from those paragraphs is that Sir Colin was not convinced by the trial judge's finding that the letter of the 14th of April 1986 from Madam Lim to Mr. Hyde was sufficient manifestation and proof for the purposes of section 53(1)(b). But in any event, as Sir Colin held at paragraph 62, the later letter, the 16th of May 1988, which in fact, as we've seen, purported to cancel the trust, provided sufficient manifestation and proof for section 53(1)(b) purposes of the trust that she had created in April 1986. Now, if section 53(1)(b) were a rule of validity as alleged by CGC, the Court of Appeal would have had to decide Ong and Ping completely differently. The trust could not have come into existence in April 1986, as Sir Colin held it did, because there was insufficient signed writing manifesting and proving the trust as at that time. Lord, I see the
You've
time.
been
Can I
in
just
there.
finish off on this point? I'll be
Yeah,
another.
I can't sit very much longer, I'm afraid. I've got a meeting at 4:30.
I can wrap it up in 5 minutes max. If that's convenient, otherwise I can resume. So you can see that Sir Colin had identified a problem with the 14th of April letter, and one can see that it was solved by a much later signed letter linking the specific house with the trust, even though it had purported to cancel the trust. And the later 1988 letter bridged the gap of manifesting and proving the trust so as to satisfy the requirements of 53(1)(b), which the court found had been declared by Madam Lim's execution of the settlement in 1986. And we say that wouldn't have been an outcome open to the court on the basis of CGC's view of the world. And then finally, just to see what Dr. Wilde says about this case, his article is Authorities, tab 156 again. And if we go to page 11,
And that's a bit later, isn't it? It's the Court of Appeal cases, I think.
so it's page 10, I'm sorry. Bottom of page 10, you see the second half of the page. My mistake, he deals with on and ping. Just read that paragraph and then just the first 3 lines on the next page when you get there.
Okay, go over the page then.
And so Dr. Wilde surmises that if the correct interpretation of the document was that it referred to the house, then the declaration itself satisfied 53(1)(b) without the need to join it with any later document. But with respect, that wrongly elides the questions of material validity of the declaration of trust and compliance with the formalities required by section 53(1)(b. As can be seen.
It completely rewrites the judgment of the Court of Appeal.
Indeed. One can see that from the passages in Sir Colin Rymer's judgment.
Because
that
the effect, the ratio of the judgment was that the original document in 1986 was insufficient.
Exactly.
But the 1988 document, although in a sense it's counterintuitive because it was a document where she was asking to cancel the trust, but it was held to be evidence that there had been a declaration of trust.
Indeed.
Which one can fully understand. So what Dr. Wilde's saying is all very interesting, but it's just wrong.
Indeed. That's my... I couldn't put it better myself. There's a conclusory remark at 4:25.
Good, that's fine. So 10:30 tomorrow morning.
All rise.